Hello and welcome to another video that Katrina and I have put together. And this time we're looking at a provision in the New Deal for consumers, which is all about dual quality goods. And this is a provision that's going to be taking effect in the EU from May 2022. And it's all about marketing goods or identically marketed goods that are being sold across the EU, but actually there are some differences in the product. So maybe the product that you're buying in France isn't the same as the product that you're buying in Poland, although it's identically marketed as such. And Katrina, there's some quite interesting history actually
Mm,
behind this and how it's come about, particularly in the food and drink space. Do you want to just tell everybody a little bit about that?
Absolutely. So the history really goes back to when Eastern European countries started joining the EU. And because of the free movement of goods, this meant that a lot of companies based in the West started putting their products on the market in Eastern European countries. And for various reasons to do with pricing, often the product they put on the market was a bit different and unfortunately of a lesser quality than the one that was being sold in the West. This was particularly in relation to food and drink. And it became something of a bugbear for consumers and also politicians in these countries that they were being sold the idea of this global brand, but actually getting a sort of less good quality version of it. And in 2017, the EU decided to address this issue and they published some guidance saying that this kind of approach would constitute a misleading omission or action under existing law. But unfortunately, that guidance didn't have the effect that was anticipated. There wasn't this wave of prosecutions. And when the EU started to look more generally at consumer law and look to kind of strengthen consumer law and develop the idea of the New Deal for consumers as a result, the decision was taken to really codify this and actually create legislation around it. And that's where we are now, that we are expecting this legislation. It was coming into force, as you say, in May 2022.
And I think the important point here is it's moved on, hasn't it? It's not no
Mm,
longer just food. This is now applying to any product, any consumer
yes.
product. So if you are selling toys or you're selling electronics or you're selling widgets,
Yes.
this is relevant to you. And I think the other point we probably just need to pick up, to deal with the Brexit question, is
Mm,
the New Deal for consumers is not part of EU retained law. So this
no.
is not going to affect you if you're based in the UK. This is going to affect you if you sell product across a number of member states within the EU. So similarly, if you're just a French business based in France, it's not going to affect you either. It's got to have that comparison
You've
across
got to
different
have,
EU member states.
yes, at least two member states and different composition or specifications between those member states for this to apply.
So let's delve a little bit more into the provision itself, because there's this
Mm,
concept of identically marketed. And I could understand people would say, well, actually, it's fine because they're not identically marketed. We use a slightly different color or we have a different
yes.
name, and therefore that's fine. This isn't going to apply to us. But it's not quite that simple, is it?
It's not because this is consumer law. So we look at it through the eyes of consumers, and the test is actually to do with what the average consumer would take away. And the reality is, consumers are not really that observant. So the, if you like, the threshold about what would be considered identical will be quite high. So what you will find, and you find this already in the testing that the EU did, that products which a marketeer would think of as quite different are actually considered to be identical because perhaps they use the same color scheme or they have the same name, but the get up is perhaps different. So I would be very cautious about taking significant comfort from sort of subtle differences in branding. In reality, I think you need your branding to be quite far apart and quite noticeably different to that average consumer for to sort of avoid the identical provision.
Okay, so if you think you're going to be caught by this, so you have products that are out in different
Mm.
member states that are very similar, but actually are different in some way, shape, or form. What are the options that you have now to try and deal with that to prepare for the New Deal legislation coming in?
Well, there are broadly three options. Obviously, you can actually change your physical product. So you can align so that you don't have any difference in specifications across the EU. Um, that is likely, well, it's certainly likely difficult to achieve and potentially commercially unattractive in the long term as well, because you may have these differences for a reason. You can, as we discussed, pull your branding apart and effectively rebrand in member states where you have a different specification. But again, commercially, you probably want to have consistent branding for very sound reasons. So that's probably, again, a commercially unattractive option. Most likely, the commercially attractive option is to find a legitimate reason. And the legislation says that you need a legitimate and objective reason why these differences exist. And if you can establish that you've got one of those, then actually the differences are acceptable. And the reason we're flagging this now is that if you have these kind of differences, you want to be delving into whether you've got a legitimate reason now, because the fallback position will be that you've got to either change your product or change your branding. And we've got what? Just over a year to go before this legislation comes into force. So if you find that you really haven't got that legitimate reason, you want to know that now so that you can start planning for those changes.
And I mean, maybe it's worth clarifying when we're talking about pulling together a dossier or putting together,
Mm.
information that's going to sufficiently substantiate this. This needs to be more than just a meeting. This actually
Oh,
needs to
yes.
be, you know, a decent amount of documentation, possibly some consumer research to back it up.
Mm,
But you want to have that file together so that if the regulator comes calling, you're able to pull it out of the bag and explain why these
exactly.
differences exist. So, I think there's also some recent developments that have taken place within Europe. There's a pilot scheme that's being talked about. Can you tell us a little bit more about
Yes.
that, Trina?
So, as well as bringing in the legislation, the EU has clearly signalled that they want to see some enforcement in this area. So, they are actually supporting consumer organisations across the EU, helping them develop testing facilities so that they can actually start testing to see if the products are actually different. And they are considering whether to create what's called a permanent observatory for dual quality goods, which means there would be a permanent body that would review how this law is working, all of which indicates that we are likely to be expecting significant enforcement.
Well, this is going to be a really interesting space to watch. So, thank you very much for joining me on this video. It's been absolutely excellent. And thank you very much as well. Goodbye.
Thank you.